3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time we walked through victim recruitment and tested what the records could actually prove without speculation. Today we are examining the grooming process and mapping what the documents show about actors, timeline decisions, and institutional response. As always, every document and source we reference is available at epsteinfiles.fm. So the first record is Haley Robson's grand jury testimony describing how she was paid $200 for each girl she brought to the Palm Beach house.
That $200 figure, it's the baseline. It's the documented starting point for the transaction.
This isn't a social introduction.
No, it's payroll. Haley Robson's testimony frames this entire process as a business. The payment makes the recruiter a contractor.
And creates an immediate conflict of interest.
It's an insurmountable one. The dynamic shifts instantly from friendship to a financial transaction. Your friend is now an employee of the system.
This is corroborated in the letter from the Palm Beach Police Chief Michael Reiter.
The May 1st, 2006 letter to State Attorney Barry Krischer.
In it, Reiter is very specific about the mechanics. He identifies a young local woman.
Yes, a woman Epstein first victimized and then, as Reiter puts it, utilized to recruit other girls.
So the system creates its own recruiters.
It's a conversion process documented by the police. Victimization first, then recruitment. The letter establishes this sequence. The system leverages the victim's trauma or perhaps her financial need and weaponizes it against her own peer group.
A transition from victim to facilitator.
Which is a clear feature of this grooming architecture we're auditing. It's a self-sustaining model.
If you cross-reference that letter with the DOJ reports in the pinpoint database, a certain vocabulary starts to appear.
Right. The early records don't use words like trafficking.
The words are befriend, spending money, and recruit.
It is the language of soft coercion. It's meant to sound less criminal.
Spending money. It sounds like an allowance, not a fee for service.
But the structure is rigid. You bring a girl, you get paid.
Yeah.
The $200 from Robson's testimony binds the recruiter to the enterprise. You are now, functionally, part of the labor force.
The documents show this pyramid structure was the engine, not a byproduct.
Correct. It was intentional. But it wasn't the only intake method.
Which brings us to the list of 28 girls document. This file aggregates a number of allegations. I want to focus on the locations.
The beauty pageants?
Miss Teen USA 1997, Miss USA 2001, Miss New Hampshire 2000.
This data is critical. It moves the recruitment mechanism out of local high schools and into institutionalized competitions.
Environments where young women are already being judged on their physical appearance.
The stated purpose of the event is judgment. The list of 28 girls cites specific allegations from Mariah Bellato, Toffa Dixon, Bridget Sullivan. They describe a consistent method.
The method of inspection.
Yes. The allegations detail powerful men, sponsors, owners entering dressing rooms, unannounced.
While contestants are undressed.
And this serves a clear purpose in the grooming architecture. It's a desensitization event. It establishes a power dynamic immediately.
Your physical boundaries are invalidated from the start.
And if security doesn't intervene, the lesson is clear. The rules of privacy don't apply to the authority figure. The baseline for what is acceptable behavior has shifted.
The document specifically mentions Mariah Bellato alleging that Donald Trump entered the dressing room during the 1997 Miss Teen USA pageant.
And the relevance for this audit isn't just the specific name. It's the environment, the pattern.
Multiple contestants corroborated the inspection for that event.
Which suggests the grooming process utilized these corporate-sanctioned events to lower defenses. If a girl is conditioned to accept that intrusion in a semi-public setting,
she is more likely to accept a similar boundary violation in a private one.
The standard for normal has been altered before she even gets near the Palm Beach house.
So once that initial contact is made, the next phase in the documented architecture is the check-in.
This is where the female accomplice becomes critical. The pinpoint database, specifically file EFTA 02731-200, describes a romantic and business partner dynamic.
And the name that appears over and over in that context is Ghislaine Maxwell.
Her role is the linchpin of the trust-building phase. She presents as sophisticated, authoritative, a woman of the world.
The pinpoint search results even differentiate the approaches. Direct, with Epstein alone, or the proxy approach?
The proxy, usually Maxwell or Sarah Kellen or Haley Robson, normalizes the entire environment. They are the bridge from the outside world into this closed system.
The files themselves provide a definition of grooming. EFTA 000169949.
A strategic pattern of behaviors to facilitate sexual abuse.
Strategic. It assigns intent.
It categorizes the actions as part of a deliberate plan. The EFTA documents show the system was designed to dismantle defenses piece by piece. The female accomplice is the primary tool.
She validates the victim's presence. She reframes the abuse.
Reframes it as eccentricity or opportunity. He can help your career. This is just how wealthy people behave.
That validation from another woman would neutralize the instinct to run.
It's designed to do exactly that. It's a powerful coercive tool.
So from recruitment, we move into the physical logistics, the introduction to the properties.
And the Palm Beach house is consistently identified as the central hub.
The writer letter to Krischer focuses almost exclusively on that residence.
He was the processing center. The case filing packages from the Palm Beach Police Department in 2006 were built around the activities there.
That's where the young local woman was operating. That's where the payments happened.
It was the logistical and financial core of the local operation.
But the operation wasn't just local. We have to audit the flight logs.
The logs are essential for understanding the isolation tactic. Once a victim is on that private plane, her dependency on the abuser increases exponentially.
She's being physically removed from her support network, from family, from friends.
And the logs show the frequency. Victims on manifests flying from Palm Beach to New York or to the U.S. Virgin Islands.
And they're on the same manifests as powerful figures. Prince Andrew, Bill Clinton, Donald Trump.
That serves two purposes. First, the geographic isolation. Second, psychological isolation. She's brought into this elite world where she feels chosen, special. It makes it harder to see the reality of the situation.
And we have sworn testimony to add detail to the logs. Johannes Joberg's deposition.
Stoberg's testimony provides the operational context. The logs place a person in a location. Joberg describes the interactions within that location.
She saw who was there. She described the layout of the properties.
Her sworn testimony corroborates the logistical data in the manifests. It confirms these properties weren't just homes. They were controlled environments.
And inside these controlled environments, there is a standard operating procedure for intake, the massage.
This appears repeatedly. It's the contractual pretext. The pinpoint database file EFTA day 00000222133 analyzes it directly.
It contains the phrase, manipulated into stripping down to her panties during the massages.
Manipulated. That's the key word from the document. The victims were told they were being hired for a job, massage therapist.
The massage was the tool used to shift the boundary. It turns a professional appointment into a sexualized encounter.
The file documents the incremental nature of the violation. The instruction to strip down to your panties creates a pseudo-medical context, a context where nudity is a requirement of the employer.
It financializes the boundary violation.
Precisely. If the victim refuses, she's not just rejecting an unwanted advance. In her mind, she is failing at her job. She's walking away from the money.
Given the recruitment targeted girls who needed money, that financial pressure was the primary lever.
It was. The massage gave a legitimate reason for her to be in a private room with him. It served as the gateway to the abuse that followed.
Which leads to the next evidence block, the progression of that abuse.
The list of 28 girls document provides a very clear map of the escalation.
We can categorize the documented allegations into stages.
Yeah.
Stage 1.
Stage 1 is non-consensual touching in semi-public settings. The document lists examples.
Groped under skirt at Manhattan nightclub, forcibly kissed behind a tapestry at Mar-a-Lago.
These acts happen on the periphery of public view. They test the victim's reaction. They also test the environment's tolerance. Does anyone intervene?
If no one does, another lesson is taught.
That this behavior is permitted. Stage 2 is isolation.
The document details incidents in more private spaces. Dressing rooms, bathrooms, massage rooms.
A specific allegation from that source is rape in Bergdorf Goodman dressing room. This is where the predator moves the victim out of the public eye. Control is tightened.
And Epstein's massage room was the ultimate Stage 2 location.
Private, soundproofed, fully controlled by the abuser.
Then Stage 3, sexual assault and rape.
Yes. And there's a notation in pinpoint database, file EFTA 0009550, that's highly relevant to this progression.
What does it say?
It notes, younger girls are easier to manipulate than grown.
That's not an observation, that's an operational philosophy.
It is the targeting strategy. Younger girls have fewer reference points. They are less likely to recognize the massage pretext as a grooming tactic until it is far too late.
They are, as the document states, easier to manipulate.
This connects directly back to the writer letter. The system required youth because youth provided a specific type of vulnerability that the architecture was built to exploit.
Another file, EFTA 0000025109, uses specific phrasing. Epstein continued this pattern of manipulation with deep of life. The text is fragmented.
But the key phrase is pattern of manipulation. It confirms this was not random, it was a repeatable, scalable process. The goal was normalization.
To make the sexual act seem like the next logical step of the massage.
To frame it as part of the job duties, an extra service. By doing that, the abuser attempts to bypass the entire concept of consent for a sexual act and replace it with compliance for a job duty.
The pattern was the business model.
It was the standard operating procedure.
Let's examine the psychological component more closely. We've talked about Maxwell's role.
The pinpoint database has direct quotes from the record. Files EFTA 0009865 and EFTA 000160024. One quote stands out.
Which one?
Regarding Maxwell. She was both charming and manipulative with me during the grooming process.
Charming and manipulative. That sounds like a description of the good cop, bad cop dynamic.
That's exactly how it functioned. Epstein was the bad cop. Demanding, intimidating, sexually aggressive. Maxwell was the good cop.
The sophisticated friend who could explain his behavior.
She normalized it. She would coach the girls on how to please him, how to avoid his anger. Her social grace was a coercive tool. She made victims feel special, which created a desire to please her.
And pleasing her meant submitting to him.
The two roles were symbiotic. One could not function without the other.
But when charm wasn't enough, the system used fear.
The Sarah Ransom emails are a key source here. Epstein file release, 13/30/16. The filings document allegations of intimidation and coercion regarding her silence.
This goes beyond manipulation into outright threats.
It does. Another file, EFT 000019994, describes a deliberate diabolical depression of grooming and submission.
Depression of submission. What does that mean in this context?
It suggests a process of psychologically breaking the victim, eroding their will to resist to the point where they are incapable of reporting what's happening.
This is where the claims about intelligence agencies come in. The Giuffre versus Maxwell deposition document DE 1158.
The deposition mentions Black Cube and Mossad.
We have to apply strict documentary discipline here.
We must be precise. Virginia Giuffre and others testify under oath that they were told Epstein had these connections.
They were told ex-Mossad agents were watching them.
That is the allegation in the sworn testimony. The threat itself is documented. The use of that narrative to instill fear is part of the record.
But is the connection itself part of the record?
No. We do not have a contract. We do not have a payment record, a wire transfer from Epstein to Black Cube or to any other intelligence agency.
So the record confirms the threat. It does not confirm the operational reality?
Correct. For the purpose of coercing a victim into silence, the belief that she's being watched by spies is just as effective as actually being watched. The psychological impact is the same, but we don't have documentation for the contracts.
Which brings us to the institutional response. Or lack of it.
Right.
Evidence block 5.
The writer letter. We have to go back to the documented conflict between the police and the prosecutor.
May 1st, 2006. Police Chief Ryder writes directly to State Attorney Krischer, and he does not mince words.
He writes, "I continue to find your office's treatment of these cases highly unusual." That is a formal accusation on the record from a police chief to a state attorney.
Ryder states that his department had established probable cause for felony charges. He said the case absolutely needed the attention of the state attorney's office.
And in response, Krischer's office suggested a notice to appear on misdemeanor charges.
A misdemeanor. For what the police chief identified as a felony sex trafficking operation involving minors.
The discrepancy is total. It cannot be reconciled. This is the documented accountability gap. The police built the case. The failure occurred at the prosecutorial level.
Ryder then goes a step further. He asks Krischer to disqualify himself.
A formal request for recusal. He's documenting his belief that the state attorney cannot handle the case impartially because of the unusual course it had already taken.
This conflict directly led to the non-prosecution agreement.
The House Oversight Committee files on Epstein, specifically Bates number 016552, detail the legal challenge to that agreement.
The 2008 case filed under the Crime Victims' Rights Act, the CVRA.
That filing documents the core institutional failure. The deal was a federal non-prosecution agreement secretly negotiated in exchange for a state plea deal.
Epstein pleaded guilty to lesser state charges to avoid the much more serious federal sex trafficking indictment.
But the critical violation, documented in the House Oversight File, is that the victims were never notified. The federal prosecutor and Epstein's defense team negotiated the deal in secret.
A direct violation of the victim's statutory rights to be heard during plea negotiations.
This is the documented institutional protection. The government failed in its duty to the victims and opted for a quiet, contained resolution.
Now we need to audit what remains unproven. The gaps in the record. Evidence Block 6.
The tapes. This is a recurring theme in the documents.
The Epstein File Release, 1332-16, contains Sarah Ransom's emails. She claims to have video evidence implicating high-profile individuals.
She alleges in those emails that the tapes exist and that she had access to them. She mentions unhackable devices.
However, in that same legal file, there is a counterclaim.
The filing from the intervener, who is representing Alan Dershowitz, argues her testimony is false, salacious, and lacks credibility. That filing is an attempt to declassify her emails specifically to impeach her credibility.
So we have a direct conflict in the legal record, an allegation and a rebuttal.
Yes. And we also have the third batch of Epstein documents.
Yes.
Which references reports about the FBI raid on the New York mansion.
Those reports mention confiscated tapes.
It is a matter of public record that the FBI seized numerous hard drives, CDs, and tapes from the safe in that house. That is a fact.
But the content of those tapes is not in the public record.
We do not have a log of what is on them. We do not have a transcript of a single video showing a crime being committed by anyone. We have Ransom's allegation, and we have the fact of the FBI seizure. The content remains unverified.
So regarding the specific content of the alleged videos, the conclusion must be...
We don't have documentation for that.
The same standard has to be applied to the intelligence connections.
We have the mentions of Mossad and other agencies in depositions. We have the documented fear of the victims who were told these stories.
But we don't have an operational reality document.
No pay stub, no contract, nothing. We must classify it as alleged in sworn depositions, but uncorroborated by any financial or contractual records available to the public.
So let's synthesize the architecture of the grooming process based only on what the documents prove.
The timeline is established. 1. Recruitment. This happens through the finders, the peer-to-peer network like Haley Robson, and through the contests, the beauty pageants.
2. Transition to the properties. This is facilitated by the massage pretext, which creates a fraudulent employment contract.
3. Psychological manipulation, primarily using the charming female accomplice, Ghislaine Maxwell, to normalize the environment and build false trust.
4. Escalation. A clear, documented progression from non-consensual touching in public to sexual assault and rape in private, controlled locations.
And 5. Institutional protection. The documented conflict between Police Chief Ryder and State Attorney Krischer, which resulted in a non-prosecution agreement that violated victims' rights.
That disconnect between the probable cause for felonies found by the police and the misdemeanor approach taken by the prosecutor's office.
That is the critical failure point. That decision, made in 2006, is the documented moment the system was protected, allowing the abuse to continue for another decade. The Ryder letter is a documented warning that was explicitly ignored.
To summarize then, the documents prove the grooming was systemic, it was bureaucratized, with set fees for recruits, and it was protected by specific legal and prosecutorial decisions made in 2006.
What remains outside the approved public record is the verified content of any alleged tapes and any confirmed contractual links to intelligence agencies.
The documents prove a machine was built to source, process, and silence victims. The machine had operators, financiers, and protectors. The question the records leave open is, who holds the leverage generated by that machine today?
Next time, Victim Testimonies Part 1.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.